Ed, thanks so much for your time today. And this Omnicare case is quite a story to tell. So why don't we begin with the simple question of
Sure.
when you entered the story.
Yeah, it goes back now about 16 years, I think. So my recollection is not precise.
No.
However,
Okay.
I'm quite certain we were in by beginning of September the 4th, I think it was.
But that was already after the merger agreement had
That
been
was-
entered into
You
and the
bet.
fighting had begun.
Yep, the merger agreement was actually signed up, I think, on July the 28th, and we got in maybe late August or early, but it was certainly by early September.
So you weren't involved at the point where they were negotiating the terms of.
Alyssa, we were not.
What was your impression of the parties when you came into the story, Ed?
Well, my impression of the directors, Alyssa, was very, very positive. My instinct was that these folks were highly motivated. They very much wanted to do the right thing, and they wanted to do it in the very difficult circumstances with which they were confronted. As I know you're well aware, NCS, a pharmaceutical company, this was a 2002 timeframe, and the company was characterized in various places as being on the brink of bankruptcy. The company was heavily shopped, by UBS. They were exploring alternatives and did so aggressively. And really, the shopping to I think 50 or perhaps more potential buyers was was not overwhelming. They didn't have overwhelming results.
And Omnicare's proposal during that time was simply to buy them out of bankruptcy, and therefore shareholders would get nothing. Is that correct?
Yeah, that's basically right. Omnicare, Alyssa, proposed what was characterized in various places, various forms, as a fire sale. It was an asset sale in bankruptcy that really did not pay creditors in full, and beyond that, provided nothing to stockholders. So, back to your first question, my instinct was that the board was very concerned about that and wanted to see that they explored and went after the best transaction they could to try to get some value for stockholders and indeed more value for creditors if they could get it.
And they did.
That's my
in
recollection.
that merger agreement. They did get something better than they'd ever been offered before.
You're right. They did. Along came Genesis, and Genesis offered additional payments to creditors, and if memory serves, about $24 million in value, in equity value, to stockholders. So it was a quite favorable result of the board's efforts at that point.
Yeah, and the creditors would all be paid, and business could go on as usual.
After the acquisition, I think that was basically correct. That's what I think the board was thinking at that point.
And there was nothing else on the table at that point.
At that point, that's correct.
So where's the dispute come from?
Well, the dispute comes from, I think, the fact that along came Genesis again, and ultimately, I think that happened in July. And they came along on after the deal was signed up on July the 28th, and asked and wanted to negotiate more.
Right,
now,
but again, it was
point,
due diligence contingent upon satisfactory due diligence, and the merger again. Let's just clarify that again.
Sure.
The board already entered into that merger agreement. That at the time it entered into that merger agreement, that was the only game in town, was Genesis.
Well, that's right. In terms of the only game in town, in terms of the consideration to stockholders and that sort of thing.
And creditors, right.
The deal was actually signed up on July the 28th, as I recall.
Right.
Genesis actually surfaced again, I think, on July the 26th. Again, we're going back 20 or 16 years.
Of course,
here.
I understand.
But they surfaced on the 26th. They wanted to talk. And at that point, Genesis had an exclusivity agreement. Genesis said it would walk if if the matter wasn't resolved, and it wasn't resolved promptly. So they hadn't actually signed up at that point. This was before the evening of the 26th, and of course Genesis had a July 28th midnight
Deadline. By the way,
drop dead date, exactly.
Your recollection of 16 years ago is right on the money. It was July 26th, and it's described as after not communicating, this is Omnicare, after not communicating directly with NCS for almost 5 months, Omnicare sends NCS a, quote, highly conditional indication of interest.
Right.
What does that mean? You know, when you have a solid offer in front of you versus a highly conditional
A
potential
legitimate
offer.
question for you to ask, Alyssa.
Yeah.
I agree. So that was the circumstances they were faced with on July the 28th. Omnicare had only offered, as you pointed out earlier, you know, an asset sale in bankruptcy with no payment to stockholders and limited payment to creditors. So what happened was on the 28th, the agreement between NCS and Genesis was signed up. Now that included, by the way, voting agreements, which we've talked about with the two key stockholders, Outcolt and Shaw, and.
Did you think they were a problem when you first looked at the matter?
You mean
The background, the fact that there were voting agreements.
Well, I certainly understood that was the kind of thing that if you were in Genesis's spot, and they had
Right.
some prior experience with Omnicare as well, and the impression that I got was that the relationship between the two parties was not necessarily great. It doesn't surprise me at all that at that point in time that Genesis wanted wanted certainty and promised and asserted essentially that it was going to walk if it didn't get that certainty, and of course the risk, and I do think the case is ultimately very much about risk. The risk was that Genesis would do exactly what it said it was going to do, which was to walk away
Right.
from the transaction. But that isn't what happened at that point in time. They signed up the deal, and it basically went forward from there. Now, shortly after that, August 29, Omnicare made a conditional proposal, subject to due diligence. August 1st, Omnicare, I think, launched its tender offer. Now, much later than that, in the year, in October of 2002, Omnicare committed at that point to what they, I believe, characterized as an irrevocable offer.
Yes, but that was how much long after?
That was, I believe, October 6th of 2002. Right. So we're months away from that.
Right. So Genesis was nothing more. If you would have not put the protections in place, Genesis would have been nothing more than a stalking horse.
I think that's right, and indeed that was
And who wants that?
They articulated that point very
Yeah.
clearly. They did not
Right.
want to be a stalking horse for Omnicare or for anybody else, and they wanted certainty in the deal, and they offered some very, very substantial value in exchange for that certainty. Obviously, as you pointed out earlier, stockholders would have gotten nothing under the original Omnicare discussion proposal. Creditors would have come up short, and that was largely addressed by the July 28th proposal with Genesis being accepted.
So the Court of Chancery's initial opinion, their decision with respect to the matter was, obviously was consistent with your thinking.
Well, that opinion came out the way we had hoped.
Right.
The Vice Chancellor, as I recall, staked out the position that the Genesis proposal was far superior to Omnicare's at that point in time.
At that point.
And of course, they were looking from a legal standpoint at the point of time where the board was acting and the board was considering its alternatives and the board was trying to do fundamentally the right thing. So obviously, the court said that it viewed the proposal as far superior, but at the same time, the court articulated what I think the board perceived earlier, which was the risk that the board and the stockholders and the creditors faced, that Omnicare, if they hadn't proceeded in the way they did, might have rescinded its proposal.
Absolutely.
The board had the board recommended against Omnicare, and there really wasn't another option. There was
They'd be
another
sued
way
for
out.
that.
Exactly. No,
That would be the breach.
yeah. So in any event, the bottom line from, I think, the Court of Chancery's standpoint was there was no probability of success on the merits. Revlon, the court said, wasn't applicable. It was ultimately going to be a combined company that was owned by its stockholders. In other words, under the Arnold versus Society for Savings analysis, it was control would have resided in the fluid aggregation of public stockholders. The board complied with its fiduciary duty to creditors, properly focused on creditors, properly complied with its duty of care, something that was obviously considered
And
later.
the merger agreement even had provisions in it where if there was a real option that arose, that the board could consider it. And the problem was nothing arose that was certain till well after the fact.
Well, I don't have any recollection that there was anything that prohibited the board from looking at evaluating proposals as they came in. However, at the same time, the transaction, the ability to go to another transaction, at that point, would have been problematic with respect to the Genesis merger agreement.
If my recollection is correct, the board, Genesis board, could move forward and have a discussion with another party if it first determined that there truly was a better offer. And that, to me, tells me that the board was complying with its fiduciary duties when it entered into the merger agreement, because it contemplated or directed what would have to be done under those circumstances.
Alyssa, what I can say, again, based upon this look back that we're trying to do here, is that board was focused. And by the way, to a certain extent, this is reflected in not only the Vice Chancellor's decision, but I think to a large degree, the majority decision in the Supreme Court, as well as certainly the two dissents
Yes.
of Justice Vesey and Justice Steele. I think this was a board that was independent, was careful, was loyal, explored its alternatives, was dealing with a very, very difficult situation, and did the very best it could under the circumstances. And I think the Vice Chancellor, in his opinion in November, where he denied the preliminary injunctive relief, I think his analysis reflects that.
And the Supreme Court noted, too, adopted all the facts that were established in the Court of Chancery.
I think that's right. I mean, I think Justice Vesey made a point of that.
Yes.
That there really were, Alyssa, no big factual disputes here.
Right.
The factual issues were almost non-existent. The question was, I think, and as I said, Justice Steele, Justice Vesey, they were very strong on this. But the real question was the risk that the board was faced with at the time it entered into the agreement, and what was right for stockholders in light of those risks, that the stockholders might end up with nothing.
So, what was your reaction when you saw the Supreme Court's opinion? Let's talk about the majority.
Okay.
The majority's opinion.
Okay. I view the case as one that, as I've probably said a few times here today, fundamentally about risk.
Right.
And I was asked by Justice Holland at the argument about why the board didn't simply say no when it came to essentially locking up the deal.
Yes.
And ultimately the answer to that was that had they done that, the very risks that they talked about, they focused on, and they worried about, that stockholders ended up with nothing and creditors end up with less than they ended up with under the Genesis deal, could very easily come to pass. All right.
Do you think
Now,
they were saying that that there's not there's no circumstance in which a board should lock up to protect themselves? I mean, it would seem to me that these
Alyssa?
would be the perfect circumstances.
I understand your viewpoint on that. I have high respect for that viewpoint. I think you're analyzing it correctly. My reaction to the Supreme Court's decision,
Yes.
the majority decision, was that I had difficulty with reconciling it with the duty of care. Why? Because, again, as you and I both well know, your duties as a director, care, loyalty, and good faith. But there was never really a question about loyalty. There wasn't a question about good
No.
faith. People were trying to do the best they could. But it was a question about I think, fundamentally the duty of care, and the direction out of the Supreme Court was you must have a fiduciary out. You got to do that. Now, I asked myself at the time, and I think Justice Steele and Justice Vesey did the same thing, how that can necessarily work, in this context where Genesis says, look, we're prepared to put money on the table, good hard cash, and really favorable terms, and they said, we're not going to be a stalking horse. That's clear from the start. So, how one goes about preserving those rights for stockholders as economic rights, and at the same time saying, well, if Omnicare decides that it's going to do something, even though it hadn't at that point, at least when the deal was signed up,
Sure.
it hadn't done that. That was problematic for me. I have to confess, as it was obviously for
the dissent. But
for
you
the
know what?
senators.
Boards, do they not enter into contracts all the time where economics falls apart, economies fall apart if you can't enforce the terms of an agreement? Circumstances can always arise that somehow you would look at a contract and say, maybe it's not the greatest thing for the company right now, but a deal's a deal. We made this deal at a time we thought it was right. I mean, did this necessity of a fiduciary out, I'm not sure how you square that with contracts in general that a company enters into that are approved by a board or officers.
I mean, I think obviously, if to the extent that the board was able to negotiate an agreement that had a fiduciary out in it, that could work under those circumstances. But you're right. In the very difficult circumstances that this board was faced with the company being basically bankrupt, with the alternative being nothing for stockholders, with the alternative being limited, less lucrative recovery for creditors, I think to take that chance and to say when Genesis made very clear they were going to walk, that they had a exclusivity agreement, and they had a drop dead date of July 28th.
Ed,
Yeah.
when you talk about the Supreme Court making a statement to the effect that you need a fiduciary out,
Right.
If my recollection is correct, the merger agreement did contain what I would consider, in any event, a fiduciary out. If my recollection is correct, it basically allowed the Board of NCS to speak to another bidder if they came with a real offer that was potentially better, and that they could change a recommendation.
All right. Well, let's break it down this way.
Okay.
I do believe that they could change their recommendation.
Mm-hmm.
They had that ability.
Right.
And indeed, as you look down the road, after Omnicare on October the 6th, put a firm offer on the table that said it was not going to be revocable. They indeed, after that, they did that, and they did say that we prefer that the stockholders get $3.50 as compared with $1.60.
Which is wonderful in October,
Okay.
but that wasn't there in July.
That's right. But on the other hand, did they have the ability to say that? They not only had it, but they in fact they exercised it. But at the same time, you will recall, and I know you do, that there were certain provisions pursuant to which the stockholders, two board members, in fact, Shaw and Outcalled, had about 65% of the vote.
Right.
And they signed lockup agreements to vote in favor of the Genesis deal. Okay, so that being the case, even though the board was able to say that the price was better, that ultimately Omnicare decided to put on the table, but it wasn't available to stockholders. That's what the preliminary injunction application before Vice Chancellor Lamb was about, and that's ultimately, which of course he denied because he thought that they had done the right thing at the time that they signed up the deal on the 28th, because it was the best deal on the table. Indeed, Justice Welch, Justice Veazey and Justice Steele said the same thing, that the board did the right thing, but at the same time, the deal itself wouldn't come unwrapped as a result of that. Vice Chancellor Lamb said he agreed with that and supported agreed to a denial of the preliminary injunction. When it got to the Supreme Court took a different view, and that's how the door was effectively opened.
If you accept the premise that there was a fiduciary duty out in the merger agreement, did the combination of the voting agreements and the irrevocable proxies give you pause? Or did you think that they would not just give you pause, but did you expect that the Supreme Court would focus on that so much?
Alyssa, I mean, to me, the whole case is all about risk analysis. And I think, the board has to play the hand it's dealt when it's dealt.
Right.
That's exactly what they did. And in doing what they did, they took what was a real difficult, challenging economic circumstances and turned it into something of very substantial value.
Agreed.
$24 million in terms of equity value to the stockholders alone. All right, so
Nothing or $1.60 or so a share.
did I think the Vice Chancellor was correct? Yes. Did I think that? Yeah, I did. I did think that. When we got to the Supreme Court, as I indicated, I did take some pressure about,
Because you
about
argued.
why you didn't just say no, and of course the answer to that we've already discussed. We've already talked about. Was I a little bit surprised? Sure, of course I was. At the same time, when you know this as well as anybody, when you're arguing one of these things, you kind of have to, you recognize that anything can happen, and sometimes it does. And of course, in this circumstance, it did. All right. So, bottom line was the Supreme Court did enjoin the deal, and as I think you know as well as anybody, what that did was open it up to further developments.
Of course.
And the 350 or 360 ultimately became 550, and the deal was done essentially on that basis. Now, at the same time, I asked myself, first of all, I do believe the opinion is really all about risk, but I asked myself, okay, the risk was that Genesis might walk. Seemingly, the analysis is still need a fiduciary out, too bad, which means you might have not have gotten the Genesis deal. If you didn't get the Genesis deal, you might not have gotten the Omnicare deal either, because based upon their track record, they were looking for an asset sale, 363 asset sale in bankruptcy. So that was a problem, but nevertheless, still had to have a fiduciary out.
And I would argue there was, but that the court seemed to focus on these voting agreements and proxies. But again,
I
the
agree.
voting agreements and proxies were done by these shareholders acting in their capacity as shareholders, with no conflict, because arguably, if they would walk away with nothing. They weren't going to approve or lock themselves up for a bad deal. They wanted shareholders to get something, and they wanted creditors paid. And that's independent of the board.
Yes, I understand it. I don't doubt that's the case. Of course, Mr. Shaw and Outcalled were two of the four directors.
Right.
Right. So they were involved in this process too. Although the other two, Boaksells and Mr. Osborne, were comprised a special committee that was obviously performed that role in the process. But Mr. Well, the two directors who signed the voting agreements that had the 65%,
Yes.
in the view of the Court of Chancery, essentially locked up the deal. Chancery would say, for good reason, and under the correct and proper circumstances, compliance with fiduciary duty. The Supreme Court said no, and I accept that.
Of course you accept that. And I suppose what troubles me about this is that it took Genesis going to the mat on this and getting a deal.
Right.
And then a couple months later,
Right.
Omnicare comes in. Those are untenable circumstances, I think, when you're managing a negotiation where you think that I'm working hard to get these terms, right? A deal's a deal, but then somebody else can come along in the last minute and cause my deal to unravel.
I understand. One reading, I suppose, of the Delaware Supreme Court's opinion is that's the way it is. That's life. In other words, but I think the consequence of that we have to be mindful of is that at the time the board was dealing with these issues,
Yes.
right? Had they not done what Genesis demanded, in essence, in order to get the high value for stockholders, the value of any sort from stockholders, because the stockholders weren't going to get anything, right? They had to go along with this. Now, if they hadn't done it, if they'd said to themselves, we got to have a fiduciary out,
Right.
what would have happened? What could have happened? Nobody knows. Nobody knows for sure. However, it's all about risk analysis. I think that's what the duty of care is about, in my judgment. So, right? And so the risk that they faced was Omnicare goes back into bankruptcy. They take the company back into the 363 bankruptcy proceeding, and potentially stockholders get nothing. I think, as I read the opinion of the Supreme Court, I think that doesn't matter. I think they have to always have to have a fiduciary out. That's how I read the opinion. I could be wrong about that. I like to be wrong about that because I don't like to see that I might have to deal with it again at some point.
And I, of course, would argue that there was a fiduciary out in the merger agreement.
I understand.
That it was the other factors that complicated things, perhaps.
I mean, I say to myself, if stockholders end up getting nothing, had the
Right.
board not done this, still have to have a fiduciary out. I don't know how that works.
So let's get a little into the dissent. That was kind of interesting. I mean, how often do you see a majority of 3 and a dissent of 2 from our Supreme Court?
You see it. I mean, it's happened before, but not very often. And indeed, I think Justice Veazey pointed out that that's a rare circumstance. And he said, hopefully this is a rare circumstance which is not going to be repeated again. The whole thing is not. And I think that prediction, at least to my limited knowledge, basically came true. That this issue has not gone back through Chancery and back up to the Supreme Court again. So, but insofar as Justice Steele was concerned, his I think point right out of the box was the board acted selflessly. They were careful. They used a fair process. There were benefits to the corporation, but really to the stockholders. He thought the court should not interfere with the business judgment of
And
these
this was
directors.
how you felt.
Well,
That's consistent.
that was
with-
certainly the position that we
You were taking.
took in the Court of Chancery and in the Delaware Supreme Court. No doubt about that.
Did the fact that, there was an order of the Supreme Court in December, but the opinion didn't come out until 4 months later, do you recall your reaction? That's hard to remember 16 years ago, but what reaction you had to that? There's an order and you don't know their analysis?
Well, we didn't know their analysis. I mean, if I'm recalling correctly, I think we did have there was an articulation in the order that you had to have a fiduciary out, and that was a focal point
Yeah.
of what they were talking about. I have nothing to add in terms of the delay in the court's opinion, other than really rank speculation. But
Right.
ordinarily, the Supreme Court acts pretty promptly in circumstances like that, particularly where you have a potential deal that's in the works. I think perhaps it might have not have been an easy one to put together, that opinion. I don't know, but it was what it was.
It was what it was, absolutely. I can only imagine, and again, I'm speculating, that I would have found it hard to accept the order and not have the analysis behind it, but nevertheless. So what ended up happening was Omnicare did come out and pay more money.
In that sense, it ended well with the stockholders getting considerable value, and that's a good thing. And of course, not only did that happen, but that was consistent with the board actually making its statement to the stockholders that their preference would be that they get $3.50 rather than $1.60, and of course they ended up getting $5.50 rather than $1.60, and so that's a good thing.
Again, after the fact.
I think the problem that I have is how this plays out in the future. Now, the interesting thing is you and I have commented already, 16 years ago, and I think people have thought about it, they've dealt with it, I'm sure worried about it. I know I have in other deal transaction situations. But I do feel that there could be circumstances which arise wherein, if literally applied, there could be harm to stockholders if things don't break the way they did in Omnicare. And hopefully, Alyssa, that never happens.
Right. Well, and although the ultimate result was not necessarily your position, you did have 2 Supreme Court justices agree with your position, so.
Well, we did, but ultimately, Alyssa, I think my position was, we thought the board was highly motivated. We wanted to do the right thing in terms of protecting them, but at the same time, it wasn't as if, once there was an agreement to pay a higher price, that anybody had any problem with that. We ultimately, when the court said what it said and did what it did, getting higher value was something the board wanted too, and the board strived for. That's why they called 50 people to try to get the best deal they could. So nobody was unhappy that I know of, anyway. We're going back 16 years, so I can't be sure. But I don't think anybody was unhappy with getting a good price. There are other potential issues, but it's for another day.
Well, thank you for letting me pick your brain about something that's so far in the past. It's very much appreciated.
It wasn't a long ways in the past, and all I can do is say I did my best here in terms of trying to bring up
whatever
I
did.
could.
Thank you.
You bet.